recent events have caused me and a number of my colleagues to revisit this issue and where the laws of Virginia are currently. It's an issue that affects everybody because most everybody has one of these, and most everybody drives. And the combination of the two has proven deadly for many in Virginia and across the country. And we need to send a message to young people and to all adults who are behind the wheel that this needs to stay in your pocket while you're behind the wheel of a car. And unless you're talking on the phone, you need to be able to keep your eyes on the road and your hands on the wheel and drive responsibly while in the Commonwealth. I chair the subcommittee on militia police that deals with this issue, and we have had a secondary offense, as you know, for many years. I supported that because I thought it was important to take a stand on texting while driving and make sure that there was a law in place to prevent it. But over the years, I think anecdotally we've seen from law enforcement and from others that it's not being followed by a large segment of the population due to the low fine that's involved and due to the fact that it's a secondary offense. So you have a situation where law enforcement is trying to follow the law. They are issuing citations, several hundred in the past year, but as AAA found in their survey, while 98% of the public thinks that texting while driving should be prohibited, 33% of the public surveyed admits doing it. So we obviously have a problem in Virginia that needs tougher laws on the books. As subcommittee chairman, I've been hearing these bills for many years. Scott's been very active on this issue for many years. And up until this year, the feeling was of the subcommittee that the reckless driving statutes of Virginia, which make it a Class 1 misdemeanor to not maintain adequate control of your car under 18.2-853, covered this type of scenario. If you had an accident or some type of serious incident where texting was a factor, that reckless could be charged and pursued in the courts. But as Delegate Surville will speak to, there was a recent case involving this issue where the judge felt obliged to only follow the secondary offense and not look to reckless for a solution. I feel, as a lawmaker, that reckless should be an option for judges, it should be an option for law enforcement, and it should be an option for prosecutors. In fact, it should be the primary option. So what I've put forward with Delegate Surville and in speaking with a number of my colleagues, hopefully it'll receive a wide array of bipartisan support, is a bill to take off the books the secondary offense so that there's no distraction about where texting while driving should be charged, but clarify in our reckless driving statute that the use of a handheld telecommunications device, a legislative word for a cell phone, the use of a cell phone when you're behind the wheel for anything other than a voice call is per se reckless driving and should be treated as such by law enforcement. Now, reckless driving carries as a Class 1 misdemeanor up to a fine of $2,500, up to 12 months in jail, either or both. Now, Class 1 misdemeanors are common throughout the code. They cover crimes that range from DUI to petty larceny to trespassing to an obscene phone call. So you have a variety of crimes that are in the same area as a Class 1 misdemeanor. But in this case, when you have the instance where you have texting while driving, you have the potential for so much harm to the public. The average text, it's been said, is the equivalent when you're driving of covering about the length of a football field blind. So if you're looking down and not keeping your eyes on the road, you're not just endangering yourself, you're endangering the entire public driving around you, the passengers, families, children, businessmen, women, elderly. Whoever can be in that car next to you is in danger because of your behavior trying to text while driving. Now, we've crafted the bill in a way that puts the texting in the negative. It essentially says anything other than a voice communication, because these things are mini computers now, and they have email, they have YouTube, they have video games, they have any number of functions on them that can be in addition to texting, but just as dangerous. So the bill is drafted broadly to bring in those activities as well. But we anticipate a lot of debate about this subject. We anticipate some amendments because the existing statute has exemptions for public safety officials. And as someone who works with public safety every day, as does Delegate Surville, I think we want them to have that flexibility that they need. But as we amend the bill, the core idea needs to be there that it should be a primary offense, coverable by our reckless driving statutes, and giving law enforcement, giving judges, and giving the citizens that enforcement ability, that protection, that safety they need when they're traveling on the roads in the Commonwealth. So I hope that it gets the support of the Senate and the administration. And with that, I would like to introduce Delegate Surville to discuss, in particular, the case that has changed my thinking on this issue from an education perspective to the need for a stronger enforcement mechanism. Delegate.
Thanks, Ben. I want to thank Delegate Klein for introducing this bill and for taking leadership on this. As he mentioned, the thinking amongst many of us in the legislature has been evolving on this issue over the last 5 years. I come at this from the point of view of a criminal defense lawyer, which is part of my practice. And my thinking has evolved on this significantly. And I'm going to tell you 3 reasons why. First of all, the studies that have come out in the last 4 years about this kind of behavior really highlighted just how dangerous it is. There was a study done on truck drivers where they put video cameras in the trucks, then somebody went back and analyzed the video. And that study, they found that you were something like 21 times more likely to be in an accident if you were texting while driving. And that was qualitatively much riskier than any other kind of distraction that was in a car. Picking up a phone was taking a phone call was only 4 times more likely, but texting was 21 times more likely. And it's because of the kinds of things that Delegate Klein mentioned. They said the average text message takes your eyes off the road for about 4.6 seconds, which at 90 miles an hour is over 400 feet. It's almost 3 football fields. And I mean, I think if anybody were to hear that somebody closed their eyes and was driving their car for that kind of distance, they would want to convict them of reckless driving. There are studies that show that over 50% of people under the age of 30 are currently texting while driving a lot. I think this behavior over the last 4 years has broadened. I mean, I get text messages now from 80-year-olds, which I didn't 5 years ago. But young people especially are using these phones a lot, all the time. They're in touch. I mean, I had my au pair, ran up a huge text messaging bill on me. Fortunately, my children can't do it yet. They're only 11, and I haven't let them. But I've heard stories from my friends about thousands of text messages on cell phone bills, and this is clearly a behavior which is growing. It's endemic, and we need to educate the public better and incentivize them not to do it. My other second reason, personal experience. Just to give you an example, on my way down here today, I did an experiment. I left Fairfax County, got on 95 South, I crossed the Occoquan, or I get on right at Route 1 where it crosses the Occoquan, and I counted the number of drivers I saw texting in Prince William County. Nothing against Prince William. The traffic lightens up a bit as soon as I gets down to Beth's Quantico. I counted 7 different drivers texting while driving in the about 10, 15 miles I went to Prince William County this morning. I see this every day driving down the Beltway to work. I think in jurisdictions like Fairfax County, Northern Virginia, where the traffic is as bad as it is, people get stuck in traffic, they start getting irritated, they start feeling like, well, I'm not going fast, I can start looking at my phone. And, it's not safe. One other experience I had recently, I had a personal injury trial I did about 4 months ago, where at the beginning you have to voir dire your jury. My case was a rear-end collision of a woman that hit her knee and incurred about $40,000 in medical bills for knee surgeries and stuff from a rear-end collision. And I wanted to ask the jury panel whether any of them had experience with rear-end collisions. So I said, who here on the panel has either hit somebody from behind, been hit from behind? Every single hand went up. And life in Northern Virginia is becoming like that. I mean, I can't tell you how many cases I've had to defend where I've had 4 cars involved and somebody running into somebody behind, and then you get the domino where one hits the other, hits the other, hits the other. Another study showed, I think the National Safety Commission last year came out with a report where they estimated that 28% of all accidents involve cell phones today. This is a problem which is growing in severity, and we all pay for it every day, not only in our car insurance premiums, but increasingly with personal injury and with our lives, which is the other thing I want to talk to you about, which is a case that I had in Northern Virginia. A family came to me about a year and a half ago now, whose son had been home. He was an 18-year-old. His name was Kyle Rowley, and he was 18 years old, had come home from college, and was working at a summer job at a restaurant. And he was driving home down Route 7, coming from Loudoun County into Fairfax. And as he was coming up the hill, he had 3 lanes of empty highway, 10:30 at night, car ran out of gas, about 20 yards short of a stoplight. So he put on his flashers, got out of the car, and he was pushing his car off the road. He was about 10 feet from getting it to the curb where he could get it off, and he was struck from behind by another man who had 2,000 feet of empty road between him, between the point where he came under a bridge where he could see my client, straight highway, 3 lanes empty. It was dark, but it was a lit road. There was dry pavement, there was no rain, no other cars in the road, and he hit my client's car without braking. There wasn't a single skid mark. He hit my client at 60 miles an hour estimated, and killed him pretty much instantly. And the driver, his car flipped and rolled. He couldn't remember anything. Nobody really saw the accident. There was one car that was up ahead that saw cars tumbling in his rearview mirror and placed a 911 call. The detectives came out and looked at the scene, and they couldn't explain how this could have happened. They have 2 wrecked cars, they have a point of impact, no skid marks, nothing out there. And the driver couldn't remember anything, so they immediately went and took the driver's phone and did a forensic on it and found dozens of text messages leading right up until the moment right before the 911 call was placed. And that was all the evidence they had. And I went and met with the Commonwealth Attorney and talked with Fairfax County Commonwealth Attorney Ray Morrow about what he intended to do about it. And they wanted to charge the individual with involuntary manslaughter. But they had this problem, which was that the General Assembly had passed a law that said if all you can show is texting while driving, it's a $25 fine. And they were seriously concerned that if they were to charge the case that way, that it wouldn't go anywhere. And so they decided instead to charge it as reckless driving, and that's effectively what happened at the trial. Was the judge looked at the evidence, and the only evidence they could really definitively prove was that this individual was texting, sending a lot of text messages right up to the point of impact. But they couldn't prove speed, they couldn't prove any other driving behavior, they couldn't prove anything because nobody could remember, nobody saw anything. And so all the judge had in front of him, when it was proven beyond reasonable doubt, was the fact that the guy was texting. And the General Assembly had defined this as solely being punishable by a $25 fine. And the judge said, I don't know how I can find him guilty of reckless because the General Assembly has said that this kind of conduct, this is how it's punished. And so he basically dismissed the charge because the guy wasn't charged with texting while driving. He was charged with reckless, and it's arguable whether it's a lesser included offense. But this person ended up being found not guilty, not punished with anything. And obviously that was, my clients were distraught by that. And that's not what the law should be. I've talked to judges that have said that but for the texting statute, they would use the general reckless driving statute to convict people of reckless for texting while driving, but they don't feel like they can anymore because the General Assembly's tied its hand. I've also had a situation, for example, I was personally defending a client on a DUI case, and he was weaving in his lane. He admitted to the trooper that he was texting while driving. And I argued it on a motion to suppress. The little statute says you can't stop somebody for that, so it was a bad stop. I didn't win, but I'm sure there's a lot of other creative lawyers around Virginia that are thinking the same way. I mean, I think this statute, in a lot of ways, has been more of an inhibition against holding people accountable than it's been helpful. And I'm not sure it's disincentivizing anybody from this kind of extremely dangerous behavior. And I personally have come around to the view that we need to do more with it, that we need to incentivize people to stop texting while driving, that we need to have punishments that are commensurate with the danger that the activity presents. And I don't think it should simply be a finable offense. Personally, I think it should be subject to reckless driving with a $2,500 fine, potentially jail time if the case merits that. And also, the other thing reckless carries that other offenses don't is a license suspension. It's up to 6 months in jail. And I think that's perfectly appropriate given this behavior, given what I see every day, given how endemic it is, and given how dangerous it is. And I'm happy to stand here with my colleague, who we frequently don't agree on criminal justice issues in the chamber. He's a prosecutor. I'm a criminal defense lawyer. He's a Republican. I'm a Democrat. But this is an issue where I think both of us agree, and I'm happy to stand here and make a bipartisan effort to try and make the law of Virginia better. So thank you for being here.
Thank you, Delegate. At this point, I want to welcome Janet Brooking she's Executive Director of Drive Smart Virginia. This issue has a coalition already advocating